Hello, my name is Andrew Flushy. I'm a Virginia traffic attorney. As we've talked about before, the DUI law in Virginia now says that for any offense of DUI, if you're convicted, to get a restricted license, you have to have ignition interlock installed. One question people ask though is, what if they don't want to drive for a year? Some people have a work situation or school situation in a way that they don't need to drive. Certainly it's convenient and people want to be able to drive in most cases, but if you have to do without it, some people can. The good news under the current law, since it's been changed, the good news is that you can simply opt to not drive for the entire 12 months if it's a first offense, and you would never have to mess with the ignition interlock requirement. Now you would still have to do the ASAP, the Virginia Alcohol Safety Action Program, and you have to do everything else the court tells you to do. But you would not have to ever get ignition interlock installed in your vehicle if it's a first offense case. That's a big departure from the previous law that before July 1st of 2012. Before then, any case of an elevated blood alcohol, so if you were charged with 0.15 or more in Virginia, and you would have to get the ignition interlock to get your license back. So it's really kind of a mess. But now, the way the law has been changed, it actually is a little bit easier and it kind of applies a little more evenly for all first offense cases. So again, on a first offense, your license has to be suspended for 12 months. If you want a restricted license and you're eligible and the court will grant it, you have to get ignition interlock for at least the first 6 months. But if you don't want to drive for 12 months and you can just walk or get other arrangements made, then you don't have to mess with ignition interlock at all, and you can save that expense and that hassle.